Got a sentencing on Christopher Davis. Good morning, sir. You're Christopher Davis.
He did want me to request a possible.
Hold on a second until she gets up here for look at this. Sorry.
Did you get that rejection on it? I did forward it to you.
Oh, yeah, it'll be here in a second, I'm sure.
Thanks.
All right. Okay. Yes, ma'am.
Your Honor, Mr. Davis wanted me to request if this could be continued to a later date due to him visiting MD Anderson. There was a CT scan performed where they saw some abnormalities. They have requested that he do a follow-up visit within the next I'm assuming, few weeks with Dr. Rajman. And so due to that, we are requesting if this could be continued one more time for him to, get some answers as to if there is actually a diagnosis.
I really would rather go ahead and go forward. I'm going to obviously give Ms. French an opportunity to make argument, even though there's some long criminal history. It is old, and it looks like, are you on a deferred probation in Kenny County right now? And so it looks like he's been on that probation, and this offense actually happened before that one. And so me sending him on a state jail felony to state jail at this point doesn't really make sense, just based on the nature of how old this case is and the fact that he's already been on a felony probation that out of another county that he's been doing satisfactorily. It looks like there's no motion to revoke.
This is a major turning point in the hearing. The judge is essentially saying that sending Davis to state jail doesn't make much sense because the case is old and he's already been successfully completing probation in another county. In other words, the court is looking at rehabilitation instead of punishment. What do you think? Should old cases carry less weight if someone has been staying out of trouble?
From the very beginning, took full responsibility.
And even while he has been revoked so many times, as the court stated, these are old cases, and I would defer to the court as to a sentence on this case, particularly given these circumstances.
All right. So, any of the objection then to going forward with sentencing?
No,
Then, Mr. Davis, at this time in clause number 25, DCCR 0010, I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to, I guess let me go back up. I have reviewed that pre-sentence report, obviously, from my statements. Y'all both have that report, correct?
Yes, Your Honor.
And any additions or corrections or objections to that report?
No, Your Honor.
And I did receive this as well. Ms. French, if you wanted to take a look at that, it's just a letter from the defendant, his mother, and then some medical documentation as well. Any reason then not to go forward with sentencing?
No, Your Honor.
All right. So again, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and I am at this time going to find you guilty of the state jail felony offense of theft of property. I'm going to sentence you to a term of 2 years in the state jail, but I'm going to probate that. You'll be on probation for 5 years. I'm going to order a $500 fine and that you follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because you will be able to serve that 2-year sentence that I gave you while you're out on probation instead of in custody. The other side of that is if you violate any condition of probation, you can be brought back into court, your probation revoked, and you could be facing the 2-year sentence that I just gave you. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Thank you. And I'm going to let you keep that since I took a look at it.
Yes.
Too. And you have Takarian Gilbo, Ms. Holmes,
Yes, Sharon.
Hey, will you on?
and we're going to count one only,
Yes,
correct?
Yes.
Mr. Valentino, in cause number 25, BCCR 0120, the state's elected to proceed on count one only. Just went away. Hold on. It alleges you committed the state jail felony offense of theft of material, aluminum, bronze, copper, or brass from April 7th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
It's not.
And are you pleading guilty because you actually did what they charged you with?
It's,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you reached with the district attorney, any right to appeal?
Yes, ma'am.
And it looks like the agreement is for an 18-month term. Oh, y'all put county jail. That's state jail, right?
It's state jail. Yes,
That's
ma'am.
right. In the state jail prison. And you would receive credit from the date of that arrest. We've talked already on the record that you were in custody in TDC from the time of this arrest. You were immediately transferred to TDC on another case, correct?
Yes, ma'am.
And the clerk has done the calculation, and it looks like that would be 600. Is that a
55. Yes, ma'am.
655 days that you would receive on your sentence. Is that your understanding?
Yes, ma'am.
You do also understand, though, that you'll have to go into custody. That time will have to be calculated. Even if you have enough credit, then you would be released as soon as that's done. Do you understand?
Yes.
Do you also understand if you're not a U.S. citizen that a plea
Notice how the judge carefully explains the immigration warning. This is standard in criminal courts because a guilty plea can have serious consequences beyond jail time. Even when everyone expects the plea to go forward, the court must make sure the defendant understands every possible outcome. It's a reminder that a criminal case can affect much more than just the sentence itself.
so that you can go into custody. You weren't prepared for that today. What I'm willing to do is reset your case for sentencing till next week on Monday, and then you can come back and we'll sentence you on that day. Yes, sir.
Judge, and speaking with Mr. Valentino, as you know, he was recently released from prison. He was able to find a job. He is working now, taking care of a sick mother. He was asking if we can get 30 days just to make sure that stuff he doesn't lose all that stuff when he, because he's going to have to go into custody. He'll be away for some amount of time after he does come back and get sentenced.
I'm not going to do 30 days. I think I understand that you've been in custody, but you also have some criminal history that gives me some concern. The most I'm willing to do is 2 weeks. Ms. Malfino, any issue with that? All right. So I'm going to reset your case for 2 weeks. Now, there's some very important things about that, which a couple of things. Number one, obviously, if you're arrested for anything between now and when you come back, I'm not going to accept this plea agreement. Things could be much worse. With your criminal history, this could be a TDC case. You could end up with more than 2, obviously more than 18 months in the state jail. Also, if you don't show up on that date, then the deal's off and there'll be a warrant for your arrest and you're looking at a lot more time. Do you understand that as well?
Yes.
Right. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Valentino is not competent?
Oh, yeah.
All right, sir, I'm going to find that you entered your plea of